Hey everyone, and welcome to This Explainer. Today, we're going to tackle a fundamental concept in criminal law that honestly affects all of us, yet it usually stays buried under a mountain of legal jargon. If you've ever wondered how the criminal justice system actually kicks into gear the second a crime is reported, well, you are in exactly the right place. Let's unpack the Criminal Procedure Code together.
So let's kick things off with a pretty common misconception, right? Does a police officer always have the immediate power to arrest someone just because a crime was reported? I mean, we see it on TV all the time. Someone makes a complaint and the cops just swoop right in. But the actual legal reality? It's heavily divided on what the police can and literally cannot do on their own.
Here is how we'll break this all down today. 1. The golden rule of arrest. 2. Cognizable versus non-cognizable offenses. 3. How police must proceed. 4. Crimes by the book. 5. A practical real-world example. And finally, 6. The quick legal quiz.
All right, jumping right into Section 1, the golden rule of arrest. Okay, so before we get totally bogged down in legal weeds, we need a solid baseline. The golden rule here categorizes crimes simply by their severity, and that severity dictates police independence. Cognizable offenses, those are serious, meaning the police can act independently. Non-cognizable offenses are less serious, meaning the police actually need a court order just to act. This right here is the absolute bedrock of the whole system.
So under the Criminal Procedure Code, offenses are basically split right down the middle based entirely on police powers to arrest and investigate. In everyday terms, can the police act immediately on their own, or do their hands remain completely tied until a magistrate gives them the green light? That single question defines the entire machine. Which brings us to Section 2, cognizable versus non-cognizable.
What's really fascinating here is the stark procedural contrast. It's like two parallel universes. For a cognizable offense, the police are fully empowered to register an FIR, a First Information Report, arrest without a warrant, and investigate immediately. No court order needed. But for a non-cognizable offense, it essentially freezes police action. No FIR, no warrantless arrest, literally no investigation without court approval. It's a completely different reality, just based on the crime's severity.
Now, for all you legal-eagles out there who want to see the exact mechanics, these specific sections act as the engine running these procedures. Section 2C and 2L define our two main terms. Section 154 governs the all-important FIR, while 155 handles information in non-cognizable cases. And finally, Sections 156 and 190 control the power to investigate and the magistrate's role. It's this intricate, perfectly balanced legal machine.
Let's see how this actually plays out in Section 3, how police must proceed. If you're dealing with a serious cognizable offense, the whole journey is built for absolute speed. Step 1, information is received. Step 2, boom, an FIR is immediately registered. Step 3, the investigation starts, right then and there. And Step 4, an arrest is made if required. No judge's warrant needed at all. The severity of the crime just demands immediate action. But wait, contrast that with a non-cognizable offense. Information is received, but then, bam, hit the brakes. Everything completely stops at Step 2, and you actually have to make an application to the magistrate. Step 3, you wait for the magistrate's order, and only after that, at Step 4, can the investigation even begin. You can really see the heavy friction introduced here, right? The law deliberately slows things down to prevent police overreach on minor issues.
Moving on to Section 4, crimes by the book. Let's make this super concrete. When you map it out, the dividing line makes total sense. You've got your heavy crimes, murder under Section 302, theft under 378, robbery under 392. These are strictly cognizable. The police jump straight in. But then look at the other side. Criminal trespass, defamation, or simple hurt, these are all non-cognizable. They absolutely require that extra step of court permission. The logic? Society obviously needs immediate police intervention for an armed robbery, but a dispute over a minor trespass or an insult, that requires a judge's oversight first.
Let's look at Section 5, a practical, real-world example.
Imagine this scenario, which honestly happens way more often than you'd think. Person A hurls some serious abuses at person B. Clear-cut defamation, right? So B goes to the police expecting swift justice. But at Step 2, the police flat out refuse to register an FIR. Now, they aren't just being difficult. Legally, they literally cannot register an FIR without a magistrate's order because defamation is non-cognizable. So moving to Step 3, B has to file an application to the magistrate. Only then, at Step 4, can the police actually investigate. Knowing this little sequence saves so much frustration at the station.
To make absolutely sure you never forget this vital distinction, let's lock in a super simple memory trick right now. Just think, COG equals can. The police can act on their own. Non-cog means they need an order from the court. COG means can. Non-cog means need. It is just a beautifully simple way to navigate a really complex procedure.
All right, let's test that out in Section 6, the quick legal quiz. Okay, question 1. In which type of offense can the police arrest a suspect without a warrant and immediately register an FIR? Think back to that golden rule we established earlier and our little memory trick. Where do the police have that immediate, independent power?
Yep, you guessed it. It's a cognizable offense. The severity of crimes like murder or robbery demands that swift, independent police action to protect society. Next question. Defamation requires a magistrate's order for police action. So what type of offense is it? Applying what we just learned about that practical example of someone hurling abuses, what category does defamation fall under?
Exactly. It's a non-cognizable offense. Because the law deems it less serious, it requires court permission before the police can do anything at all.
You know, understanding the difference between cog and non-cog is genuinely empowering. It stops you from feeling totally helpless against bureaucratic friction. But it also leaves us with a much larger question to ponder. In a modern society, exactly where do we draw the line between needing immediate police protection and protecting citizens from unchecked police power over minor disputes? Well, thank you so much for joining me in this explainer today. Keep learning, keep questioning, and I'll see you next time.